Hi everyone, today I'll do a brief expose on the need to formalize our everyday agreements. We often engage in transactions or impose duties and liabilities or make promises and fail to protect ourselves with formal written contracts. This session will expose the advantages of formal and written contracts or written contracts. By nature, contracts could either be legal or formal and informal. Informal contracts are those gentlemen's agreements which are premised on honor and are not enforceable by law. Basically, a contract is a binding agreement between two or more parties which states out promises, establishes obligations, rights, and responsibilities of the parties involved with respect to a particular subject matter. In view of that, contracts can be created for every situation where a promise is made, an obligation is established, or obligations are established between two or more parties, or there is an agreement for the performance of a particular service or certain obligation. What are these everyday contracts we refer to? There are common contracts which are often engaged in or which on a daily basis we go into without actually taking note that they are meant to be formalized. These contracts could be partnership agreements, they could be non-disclosure agreements, they could be service contracts, they could be facility or loan agreements, and the like of others. So what are the advantages of formal written contracts? Written contracts define and clarify the terms and nature of a relationship, a communication, agreements, and set out the obligations of contracting parties. Formal contracts also help for better management of business relationships and partnerships. So where there is an engagement or a transaction between two or more parties or an agreement to partner for the performance of a service or with respect to a particular subject matter, it becomes easier to set out obligations or duties and liabilities of each party in that partnership and to make it binding on each party with that particular contract document. So also, formal contracts ensure better and easier enforcement of the terms agreed to, and they serve as proof of the agreements or representations made by the parties involved. Clearly, it will be easier to prove the existence of a contract when it is written than when it is made orally. So, contracts or formal contracts also avoid approbation and reprobation of parties. I will explain. Where a particular party has made a representation or a promise to the other that certain obligations will be fulfilled or a service will be performed, for example, at a certain rate, or a product will be sold at a certain rate. It is easier to protect the rights of the parties if it is written down, and it will make it difficult for that same party to go back on their word or reprobate or change or alter the terms of those agreements agreed to initially. So contracts or formal contracts also help with the protection of property. It could be real or intellectual property. These days people come up with innovations, they come up with ideas which they decide to share with people in order to ascertain the viability of those innovations. In such situations, you could protect your innovation, you could protect your rights with respect to that innovation by going into an NDA, by signing a non-disclosure agreement or confidentiality agreement with the party you're disclosing to. This will protect your innovation, to protect the other person from going behind you, for example, to expose your innovation. Also, formal contracts prevent or avoid the potential disputes and also help for management of those disputes thereof. So, oftentimes the contracts or agreements, written contracts, usually have dispute resolution clauses which state out how or the procedure which should be taken where there is a dispute with respect to that contract. For example, It could be negotiation. People and parties could opt to sever their relationships by going to alternative dispute resolution, negotiation, conciliation, mediation, or arbitration even. Some people go straight to court and all, but it helps to state out a procedure for dispute resolution. Formal contracts also prevent misrepresentations of communications and agreements. In view of the advantages of formal contracts and the large number of disputes that arise as a result of contractual relationships, it has become pertinent to document agreements which are ordinarily left undefined. For example, loan agreements, even between family and friends. So where you give out a loan to another person, it is better off to set out the terms of that loan in a written agreement, to set out the payment terms, the payment procedure, where it should be paid to, and when it should be repaid. There are also non-disclosure agreements or confidentiality agreements, partnership agreements, collaboration agreements. So where you're collaborating or you're agreeing to do a particular thing, a particular business, a particular service with another person, it's better off to define the extent of your relationship, the nature of your relationship with that person, considering that it is a business relationship. Hire purchase agreements, car sale, it is good to document the terms on which cars are sold or other property are sold generally. Everyday service agreements, you're procuring the service of a particular person, it is good to formalize that engagement, that transaction with a formal or written contract. So there are a number of things that we should look out to when we want to contract or want to put down our terms, the terms of our transactions in a formal document. So these are often the elements of a binding contract and inclusive of things that we should look out for when contracting and reviewing contracts. For example, we should note the capacity of the person we're contracting with. We're also expected to have capacity to go into a particular contract. It is very important to ensure capacity. This will avoid or prevent you incurring losses or prevent the contract from becoming void or voidable. So we should understand the scope or purpose of our contract before having to put it down in writing. We should understand the commensurate nature of the consideration. One element of contract is also consideration, which is more or less the value, the money value, for example, of the contract in question or the subject matter in question. We should understand risk allocation. Risk is better borne by the party in a position to prevent a loss. We should understand the consequences of breach and the remedies to breach of such a contract. We should also define our termination rights and force majeure clauses. A force majeure is an unforeseeable circumstance that prevents the fulfillment or performance of a contract term or contract terms in general. With the outbreak of COVID-19, this particular clause has become very important in contracts as it has opened our eyes to more reasons why we should consider other unforeseeable circumstances that could arise with respect to particular subject matter. We should understand the rights and obligations or liabilities of each party in that contract. We should define indemnification provisions or understand indemnification provisions. Indemnification generally requires holding parties harmless for certain liabilities that arise. So it becomes necessary to be careful the terms and extent to which a party is indemnified and also negotiate a similar indemnity for ourselves. We should note confidentiality provisions, the extent of confidentiality terms. We should note payment procedures where necessary. We should note third parties, their liabilities and indemnification thereof. Thank you. I hope this brief session has been useful and it has reiterated the need to formalize or document our everyday engagements. Kindly feel free to contact me with your questions directly via mail or leave questions in the comment section. Thank you.